Hi everyone, in today's video I have an exciting update to share with you regarding a new policy by USCIS. And this policy specifically has to do with work authorization for the derivative beneficiary of certain non-immigrant visas. Well, USCIS has announced a new policy that's going to make it much easier for these spouses to be able to get their work authorization. And we're going to talk all about that in today's video, so make sure to stick around. Hi everyone, my name is Michael Ashoori and I'm a U.S. immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and worldwide. And we regularly post videos to make sure that you're up to date with the latest USCIS news, the latest immigration trends and updates. So if you haven't yet subscribed to our YouTube channel, make sure to hit that subscribe button right away. Also, please make sure to give this video a big thumbs up so that YouTube knows to share this information with more people. So as I mentioned, in today's video, I have a wonderful new update to discuss with you. And again, this update has to do with work authorization for certain beneficiaries of non-immigrant visas, specifically the spouse of a principal applicant for certain non-immigrant visas. So let me take a step back and explain what's going on exactly. So there are two non-immigrant visa options that are wonderful options for the right candidate. And these options are the L1 visa and the E2 visa. The L1 visa is a visa that allows a foreign company to transfer certain workers to work for a related US company. And the E2 visa is an investor visa. It allows somebody to invest in a US business and to operate that business in the United States. So these two are tremendous visa options. And one of the unique benefits of both of these visas is that they allow the spouse of the primary applicant to get their own visa and to also get work authorization to be able to work in the United States. And it's great because the work authorization that the spouse gets, the spouse, by the way, is referred to as the derivative beneficiary. And again, the work authorization that the spouse gets is even greater than the work authorization of the primary applicant. In the context of an L1 visa, the primary applicant is only eligible to work for the L1 employer. And similarly, in the context of an E2 visa, the E2 principal applicant, the investor, is only authorized to work for the E2 company. However, the spouse of both the L1 visa holder and the E2 visa holder gets employment authorization that authorizes them to work in any lawful employment. They can work for their own company, they can work for any other lawful employer in the United States. So it's truly a wonderful benefit. Now here's where the update comes into play. In the past, when the spouse of an L1 visa holder or an E2 visa holder would get their visa, they would have to enter the United States and then they would have to apply for work authorization by filing a Form I-765 with USCIS. The Form I-765 is an application for work authorization. And again, in order for the spouse to get and qualify for the work authorization that came with their visa, they would have to apply for it through USCIS. This was both a time-consuming process and a tedious process, because first they would have to come to the United States, then they would have to fill out this additional paperwork, and then it would take several months for this paperwork to get approved, and only then could they begin working. Well, the good news is that USCIS has done away with this policy requiring the spouse to apply for work authorization once they're in the United States. Instead, USCIS has revised the policy so that spouses of L1 visa holders that get their own visa, their L2 visa, and spouses of E2 visa holders that get their own E2 visa automatically get work authorization based on their status. So basically, USCIS has modified this policy so that spouses of L1 visa holders that have their L2 visa and spouses of E2 visa holders that have their E2 visa no longer have to apply for work authorization by filing a Form I-765 with USCIS. Instead, these derivative beneficiaries, these spouses will automatically get work authorization incident to their status. So they no longer have to apply for their work authorization. Their work authorization is automatically granted based on their status as either L2 or E2. This is truly wonderful news because it means that these spouses will no longer have to go through the tedious process of applying for work authorization, and they no longer have to wait several months just to get work authorization. Again, it's wonderful news, and what I want to do next is share my screen with you and read through some of the policy highlights. So take a look at my screen and we'll go from there. So if you take a look at my screen, we're looking at a USCIS policy alert that's dated November 12th, 2021. And the subject says employment authorization for certain H4, E, and L non-immigrant dependent spouses. So this policy alert has a lot of different information in it, but I'm going to scroll to the section that has to do with the topic of today's video. So it says here, in addition, USCIS is also clarifying that it will consider E and L dependent spouses to be employment authorized incident to their valid E or L non-immigrant status. Since the 2002 INS memorandum, which was issued to implement new legislation, E and L spouses have been required to request employment authorization by filing an application for employment authorization, Form I-765, and receive an EAD before beginning employment. Therefore, the 2002 INS memorandum is suspended by this updated policy guidance. USCIS will continue to issue E and L dependent spouses EADs upon request via Form I-765. Such EADs are acceptable for employment eligibility verification, Form I-9, as List A documents evidencing both employment authorization and identity. DHS, the Department of Homeland Security, will immediately take steps to modify Form I-94, evidencing non-immigrant status issued to E and L dependents, so that E and L dependent spouses can be distinguished from E and L dependent children on the face of the document. Once these changes are made, the revised Form I-94, containing a notation indicating that the bearer is an E or L dependent spouse, will be acceptable as evidence of employment authorization under List C of Form I-9. This guidance contained in Volume 10 of this policy manual is effective immediately. The guidance contained in the policy manual is controlling and supersedes any related prior guidance. So I'm just going to scroll to the policy highlights right here, and I'm going to go through one important highlight, and it says right here. So again, this policy alert that we're going over, one of the policy highlights evidenced right here in this bullet point says, provides that E and L dependent spouses are employment authorized incident to their status, and therefore they are no longer required to request employment authorization by filing Form I-765, but may continue to file Form I-765 if they choose to receive an EAD. So there you have it. Based on that policy alert, we can see very clearly that USCIS is changing its policy so that the derivative beneficiary spouses of E and L visa holders will now be eligible to have work authorization incident to their non-immigrant status. They no longer have to go through this tedious process of applying for work authorization by filing a Form I-765 and waiting months and months and months for that to get approved before they can begin working. Again, now what we can see is that these individuals, these spouses of E and L visa holders that get their visa as the derivative beneficiary will now be eligible to work in the United States incident to their status. They will no longer have to affirmatively apply for work authorization. Again, this is wonderful news. One more point, as you can see from that alert, we saw that USCIS still leaves it open if somebody wishes to file their Form I-765, to get a copy of their EAD, to get an EAD card, they're still eligible to do that, but they will not be required to do that to prove work authorization. I hope this news helps to brighten up your day. I hope you like this news. If you know anybody that can benefit from this information, please make sure to share this video with them. Again, at our law firm, we're all about empowering you with knowledge and keeping you up to date with the latest immigration news and the latest immigration trends. So as always, thank you so much for tuning into this video, and I will see you on the next one.